In the second case, that's the case of Dusenberry and Searles, this is also reported in the Family Court Reports at FAMCA 101, and it's reported on the 10th of February 2011. This was a case where the parties had a 19-year marriage from 1980 through to 1999. They separated and consent orders were made in 2001 for all property except superannuation. That was adjourned under 79(5) until the husband met his commutation point at age 60. The husband had received his superannuation by way of an invalidity payment and was receiving an indexed pension which was payable for the remainder of his life. His preservation age and commutation point was coming up to age 60. He was about to reach that when the wife made an application for enforcement of the consent order made in 2001 in such a way that the husband would be required to commute his superannuation and then pay 50% of the commuted amount to the wife. There are a couple of superannuation issues which were live in this particular case. The first was that the husband made a submission that Part 8B did not apply to this form of superannuation. After some explanation from the court, the husband then quickly abandoned this as a line of argument, and rightly so. Secondly, no one had bothered to tell the trustee that these proceedings were on, and so procedural fairness was therefore not accorded to the trustee. The court noted that in those circumstances, the procedural fairness not being satisfied, the court would not be able to make a splitting order in the circumstances of the case. However, given that the application was for a commutation of the superannuation pension, the lump sum that would be delivered to the husband on commutation would then be made outside superannuation, so it would no longer be a superannuation payment. In those circumstances, a splitting order was really not the appropriate form of order. So the question before the court was, could it make the order to order the husband to exercise his commutation right? And secondly, if it did, how was it going to ensure that 50% was to be paid to the wife? The court had no difficulty in finding that it had power, as the older case of Law Smith and Seymour demonstrates that the court does have power to order a party to withdraw their superannuation in a particular form, where that is within their power. In this particular case, the husband had a commutation right, and so he was ordered to exercise that right. The next point, of course, was the court was concerned that if the money found its way directly into the husband's hands, and I should note at this point that shortly after the husband's invalidity and failure of his marriage, he departed Australia and was living overseas. So the court was concerned that if the superannuation monies found its way directly into the husband's hands, he would abscond and not satisfy the payment to the wife. So the court made some additional protective orders so that the commutation payment was then paid into a trust account, and there were orders about the disbursement of the monies from the solicitor's trust account, 50% to the wife and the balance to the husband. So this case is a useful case to demonstrate one of the more creative ways of satisfying a property order, taking into account the fact that somebody had a superannuation commutation right, which then enabled the court to obtain a clean financial break between the parties. Now, we've uploaded both of these cases, and they're under our recent cases tab on the website, so we invite you to have a look at those, review the reasons, and trust you enjoy the website.